Hello and a very warm welcome to you. This is the Courthouse, our law class 101, where we get to learn the law together in plain, simple and entertaining language. I'm Olomu-Agbodo. When we return from this quick break, we'll tell you what we'll be discussing this week. Stay with us.
From Lagos
to London, from Johannesburg
For several years, our economy
to the United States,
identifying houses of worship.
we have all the world covered for you, no matter where you are.
Love with News is at the heart of it all.
Have experience.
We bring you our perspectives of stories behind the story.
The signs given to us for the entry of these things are before us.
Join us.
Join us.
Join us on this station.
Yeah, welcome back. This is the Courthouse, our law class 101, I like to call it. And this week, we're taking another look at an aspect of labor law stemming from our discussion on casualization of workers, rights of casual workers, and the like. And that topic is redundancy. A nice sounding word, but it has some grave implications. What is the meaning of redundancy? What are the implications if you hear the term redundancy? This is what we are going to be finding out this week on the show. And as usual, we're joined by a distinguished legal practitioner who was here to talk about casualization of workers and the rights of casual workers. He's gracing the courthouse again to talk about this concept of redundancy, and he is Don Akaegbu. You're welcome to the courthouse.
Thank you very much.
Okay, and thank you for making our time to elaborate more on this aspect of our previous discussion.
Very well.
So, redundancy, what's the meaning of redundancy in the eyes of the law?
Well, starting from the Court of Appeal has described redundancy in the case of PAN, P-A-N, versus OJ as a mode of removing an employee from his post when his post is declared redundant.
Okay.
But that doesn't sound
like it's clarifying anything.
Very well. But the Labour Act, Nigerian Labour Act, in Section 20 has given us a more detailed and clearer definition. And in Section 20 of the said Labour Act, subsection 3, redundancy means involuntary and permanent loss of employment caused by excess manpower.
Involuntary and permanent
loss of employment
caused by excess of manpower. And recently, why this topic became very interesting and why we felt we needed to clarify is that we've been seeing headlines of people being, their posts being declared redundant, people listed as those under the redundancy list. So what's the scope, what's the concept, the scope behind this redundancy?
Well, we have voluntary redundancy and compulsory redundancy. Voluntary, as it sounds, is where the worker is given an incentive to accept redundancy.
Okay.
That is, you are not foisting.
Accept this amount of money.
Very well.
And go.
It's all about negotiation. Even an incentive in form of money or something else, and make him declare himself redundant or make him leave the workplace without hazards. Compulsory is the one that your employer has foisted on you.
On you by force.
By
you
force.
have no choice.
You just have to leave.
So now you just talked about the fact that there are two basic types. The voluntary one, where you are given a choice with a package and all that, you negotiate with your employer and you leave.
Very well.
Then there's the compulsory one that is foisted on you.
Yes.
I think that one seems to be like the most common at the moment because we've been seeing newspaper headlines on this issue, and I don't think most of these employees are given the opportunity to negotiate or something like that.
Well, there are implications of refusal to negotiate because there are laid down regulations and procedures. for redundancy declaration. Here in Nigeria, the Act, Section 20 of the Labour Act, has prescribed procedures to be adhered to. And the operative word is shall, not may. That means you must adhere strictly to the procedures.
Okay.
The first of which is that you, the employer, must inform the work representative or labor union, the relevant labor union, about the reason and the extent of the redundancy. And Section 20, subsection 1B makes it compulsory to negotiate with these workers.
Okay.
Yes.
You know, in our previous discussion, when you started talking about the fact that the labor unions need to represent these workers,
yes,
we brought the issue of the private sector, where most of them are not even allowed to sign any, most of them are not allowed to join any unions. And you talked about the yellow dog contract that they are made to sign.
Yes.
That contract specifically says they shouldn't join any union.
Yes.
So how do people in these private sectors, how do they negotiate their redundancy pay?
Recall that where we talked about not negotiating with these workers is when we talked about casual workers.
Yeah.
For regular workers, at a standard employment, there is labor contract that contains what we call severance package.
Okay.
Severance package is a form of redundancy. What happens in the event of redundancy?
Okay.
Right? That is captured in made part of the employment contract. But you see, here in Nigeria, Section 20, subsection 2 says the labor minister can make regulations to regulate either in part or in full the issue of redundancy. I mean, the labor minister can say for this sector of work or this category of workers, severance package, redundancy pay is compulsory. But since we don't have any such regulation at the moment, we make do with what we get from the employment contract.
Yeah.
Again, employment contract, because you know what contract means. Contract is agreement.
Agreement.
Employment contracts ought to be negotiated, but are often not. So that's the position here.
Okay.
Unlike what obtains in some other clients,
parts of the world,
jurisdictions.
And I want to sort of recall part of that discussion we had when you talked about the fact that these workers are supposed to be represented, and that under the ILO conventions, workers also have a right to join associations. So
Yes.
we want you to take a look at this clip, this excerpt from our last discussion on casual workers and their rights. Just a snippet. We'll be right back. We see casual workers belonging to any union at the end of the day.
But you see, pursuant to Section 40 of our Constitution, Section 1 of the Trade Union Act, and various ILO, that is International Labour Organization conventions, like that of 1951, 1958, they are actually against discrimination of workers and prohibiting them from participating
collective bargaining efforts.
Very well.
Yes.
Now, they are also entitled to unionize pursuant to decided cases by National Industrial Court of Nigeria. There are several decided cases to that effect, that casual workers are entitled to unionize. But like I said, they are meant to, they are forced to sign yellow dog contract prohibiting them from participating in union activities. So you can see that this constitutional right is observed in breach. And again, because their take-home pay cannot even take them home, let alone engaging lawyers to seek redress in courts, they stay with the condition foisted on them by the employers.
Well, you're welcome back. So that makes it very compulsory for workers, whether they are called casual workers or not, to have a right to association, because it's still part of their fundamental right to belong to an association of their choice freely. So,
Very well.
bringing us back to this issue of negotiation and contracts, agreements, and all that. You said contract is the operative word, agreement is the operative word, knowing fully well that in some industries, some companies, establishments, or whatever they will be called, they do not even give you contract. It's either you take it or you leave it. What happens?
You see, talking about the importance of allowing workers to unionize. You see, allowing an individual worker to negotiate with the almighty employer is, in my view, is what I call unconscionable bargain, right? Because the weight of the employer certainly will outweigh
That of the employee.
that of the employee. That is where the right to unionize becomes very important. Because if you are a member of a union or you are being represented by workers' union, you take the benefit of what we call collective bargaining, which gives birth to collective agreement. In collective agreement, there can be opportunity to negotiate what the severance package of an employer should look like, and the procedures that must be followed. Once that is agreed and signed by both workers' representative and employers' representative, that becomes the law, and any individual worker can take benefit of that.
Okay,
Yes.
so now that brings us to this question of now the industry, the union in that particular industry is representing them, and basically they've negotiated the severance package and all that. So bringing us to the procedure to follow in terms of redundancy, now you're declaring this worker in this sector, in this industry, redundant. What are the procedure to follow? Assuming there's a contract.
Yes.
You said there could be a negotiation. Let's assume this is a compulsory redundancy. Is there any position that the law stipulates that must be followed in issues of compulsory redundancy?
Like we said, workers and their employers are at liberty to reach an agreement, even if it is over and above the provisions of the certain law. For instance, here in Lagos State, it is only where there is a written tenancy agreement that it will not be regulated by the provisions of the tenancy law. But the provisions of the tenancy law makes provision for the number of notices to be given to individual tenants in the event that they didn't agree otherwise in their agreement. Now, in collective bargaining, workers and their employers are at liberty to have detailed agreement. But in the event that there is no agreement whatsoever, the provisions of Section 20
Of the Labour Act.
of the Labour Act has prescribed the procedure, which is that you must give notice to the workers' representative or the labor union. You must also try to negotiate with the workers. But there's something more. That's what the principle we call the principle of last in, first out.
Okay.
The principle of last in.
It's already sounding interesting. Last in, first out. Okay.
Last in, first out.
Give it to us.
This simply means that if you are the last to be employed, you must certainly be the first to be kicked out, not otherwise.
Okay.
But again, this principle has a number of exceptions, which is the skill, the reliability, the capability, and the skill of workers. Okay. These are some of the exceptions.
So I like the exceptions that you just pointed out, the skill of the worker, the capabilities and all that, the responsibility.
Yes.
So basically this will now be like the personal characteristics of that particular employee that will either determine whether it's going to be kicked out or left to remain.
Very well.
Okay, so now this issue plaguing the world, the global economy, saw a growth impact during the lockdown. A lot of countries had to shut down. People said they declared bankruptcy and all that. People are relying on this situation to say, oh, go home. No need to negotiate. Compulsorily, they are sending people out. How does the redundancy law apply here?
Well, from the media, It looks so, but it's not exactly so. For instance, Arsenal has declared
About 55.
proposed, it is still called proposed.
Okay.
Yes, it is still called proposed redundancy. And part of their rules and regulation is what we call the 30-day consultation period.
30-day consultation
Yes,
period.
30-day consultation period. They may not tell you this on news media, but it's not as though you just come and foist redundancy on the workers. You just have to negotiate with them. You must follow laid-down procedures.
So you talked about the 30-day procedure. If the 30 days is over, what happens?
Well, 30-day consultation period is the time within which to negotiate, because you can't just foist it on them. You can't wake up one day and say the staff should leave. In civilized climes, you can't just stand up and say they should leave. You just have to negotiate with them.
Okay.
The package, the extent. Besides, in countries where we have redundancy law, in Nigeria, we don't have redundancy law. We just have it as a section in our labor law.
Act, yeah.
In countries where we have redundancy law, like the UK, you must comply with every bit of that law before an employer is asked to leave.
Okay.
Which includes this negotiation.
And
like in the
consultation period.
Like in the UK, if you have worked up to 12 years, you are entitled to minimum period of 12 weeks notice.
Okay.
Right? And in some countries, like I said, that have redundancy law, the notice in some organizations include timeout. The timeout is the time given to an employer to get alternative employment somewhere else while still entitled to his or her pay in the current employment. The time given to the employer to be affected by the redundancy, whatever, to get alternative jobs somewhere else.
I think I like this particular provision of the redundancy law,
Yes.
wherever the law is applicable.
Yes.
But we want to take a listen to a report. We have a short report on this and, of course, some of our legal nuggets. We'll be right back. Stay with us. In times of economic depression, such as is being currently experienced globally, employers of labor, especially in the private sector, always consider cost-cutting measures that will enable them remain in business. The first option that may likely be considered is to resort to redundancies, even though this may indeed not be the only course of action. There is no common definition for the concept of redundancy in labor law and relations the world over. Each nation appears to define it in line with its own jurisprudential leaning. According to the Nigerian Labour Act, redundancy means an involuntary and permanent loss of employment that is caused by an excess of manpower. Going by this statutory definition, labor redundancy in the Nigerian context is brought about only when there is excess of manpower in an organization. This condition is likely to arise due to factors such as introduction of machinery in place of manual service, thereby reducing the number of personnel required to operate the machine to only those who possess the requisite skill to man the machine. In other words, a redundancy occurs when the services of a worker, having been in the continuous employment of an employer, are no longer required by that employer due to no fault of the worker, but due to exigencies of the employer's business not being able to accommodate the services of the employee anymore. The concept of redundancy provided above appears too wide to allow for precision and certainty in the law. It has been observed that no single measure can provide conclusive evidence of labor redundancy in an enterprise. On the contrary, several combinations need to be applied. However, the important thing to note is that the procedure must be followed for redundancy to stand in the eye of the law. You're welcome back. This is still the courthouse, and we are still talking about redundancy and how it is playing out in the world now as a result of the global lockdown and the economic impact that the world basically suffered. And we still have Don Akaegbu telling us about what redundancy is all about, the procedure to follow, and the like. Now, you were talking about the fact that there's a redundancy law in some other climes, some other jurisdictions, and you mentioned the fact you were giving us some instances of the clauses that are contained in that law, the provisions contained in that law. Can you elaborate more on the provisions of the redundancy law? We know it's just a section, it's just part of a section in our Labour Act in Nigeria. So elaborate more on the redundancy law outside Nigeria.
Let's take a look at an Arsenal scenario.
Yes.
The Arsenal scenario is that you must follow the stipulated procedure.
Okay.
And in the operative word is also shall.
Which is mandatory.
Which is mandatory. Part of which is the 30-day consultation period I mentioned.
Okay.
Right? The reason is to ensure that you are not witch hunting a particular employer or category of workers. That's the reason why we have these stipulations and regulations, so that it don't wake up and under the pretense of a shambolic redundancy declaration, you target a worker and ease him out. These procedures are steps that must be followed, just like even in the Labour Act prescribes. That is what obtains in several nations. But like I said, they are more detailed in nations that have redundancy law as an individual regulation, individual legislation, unlike what we have in Nigeria. And talking about the Arsenal scenario again, I like to let you know that at the moment, what we call the Arsenal Supporters Trust, AST, they are working behind the scene to ensure that the affected employees get as much financial help as possible. We don't have that here in Nigeria, right?
We don't have it at all.
We don't have it here in Nigeria.
This is even making redundancy sound very attractive.
Yes.
Because if you're negotiating benefits and pays and all that, trying to basically cushion their effects. And some other jurisdictions, they try to give you your pay before tax and all that. Is the way it's negotiated, your pay before tax.
Yes.
So in this Arsenal scenario, you talked about the fans' trust, and which seem to be playing out nicely for them.
Yes.
It means like you're letting them go on an easy note, giving them a soft landing. Give us some other examples, maybe some other jurisdictions that elsewhere in Africa. Is there any other place that actually encourages this redundancy package to be enforced before letting workers go?
Well, you see, all nations are minded to give the best possible financial assistance to the citizens. So basically, all nations have their rules and procedures. But at the moment, like the nations are overwhelmed. I'm sure you know that
because we saw the story of how the palliatives went, and a lot of
you're talking about Nigeria.
water under the bridge.
I want to talk about the UK. Leave Nigeria apart.
Let's leave Nigeria.
Yes,
okay.
the UK at the moment has officially entered recession.
Yes.
The first in a period of about 11 years. You see, the economic outlook of nations makes this redundancy issue a loose thing. A loose thing, except somebody who can stand up and decide to enforce his rights in court. The nations cannot really do much. Although in Nigeria, we saw that the Ministry of Labour did something good at the resumption of work immediately after the lockdown period, when Access Bank
tried to lay
off a certain number of workers. The Nigerian Ministry of Labour weighed in to stop them. To stop them. They've done something. But you see, this issue of redundancy, the law says is caused by excess of manpower. But when you look at it, is it really caused by excess of manpower? There are a lot of factors. Although when I was asked somewhere else, I said, well, is either the cup is half full or half empty. Excess of manpower can be occasioned by economic hardship.
Yes.
Right? Economic hardship in the sense that you can no longer pay certain number of workers. When you don't have money to pay certain number of workers, you can say those workers are redundant.
Excess, yes.
Are excess. Maybe you should be looking at the things that can cause redundancy. Technological advancement cause redundancy.
Use of machines instead of people.
Yes, change of direction can cause redundancy. Change of business can cause redundancy. There are certain number of things that can cause redundancy, which is the reason why it will not be equitable to say you cannot declare some workers redundant.
Okay.
It will never be equitable. You can only enforce the procedures, particularly that of negotiation. All right.
But the way it's looking, doesn't it sound as it's going to sound as though the severance package in terms of redundancy, it's more expensive than paying the worker for a period of like 3 or 4 months. The way it's being painted out at the moment. Not in Nigeria, not in private sectors where you can just say hire and fire, go and don't come back.
It depends on what is occasioning the redundancy.
Okay, first measure.
Say a company wants to change its business line completely, and the type of staff on ground cannot fit into the next level or the next phase of business, the next line of action of the outfit.
Yes.
The workers certainly will be laid off.
But give us the alternatives anyway. Let's just get that.
Alternative, like saying you work hourly.
Okay.
You work when work is available.
Okay.
Right? And when you work when work is available, you are a casual worker. Right? Instead of laying the worker off completely.
Yes.
Particularly where there is no provision for timeout. Like I mentioned earlier, timeout.
Last in, first to go.
No. Timeout.
Timeout, you get work somewhere else.
You get work somewhere else.
Being paid in your former place of
yes.
employment.
You are allowed time, you are given a time to secure job somewhere else before you are completely laid off. In places where we don't have such thing, it works hardship on employers to lay them off without nice severance package and no opportunity to secure job somewhere else.
Okay. Your final thoughts on this topic, probably like giving us reforms. You know, you mentioned the fact that our Labor Act has just a mention of redundancy and no stipulated provisions per se, no outline, full outline on that. Give us some reforms that you like to see in our labor laws or generally in the area of redundancy.
In Nigeria, I would like us to have redundancy law.
Okay.
Or the minister taking advantage of section 20, subsection 2 to make regulations, compulsory regulations that will ensure that workers are paid their redundancy package before easing them out, unlike what obtains at the moment.
Okay, quite interesting. We had a very interesting chat with Don Akaegbu talking about redundancy and giving us the procedure to follow. And of course, he has also made some recommendations like working early instead of just sending people out, calling them when work is available and things like that. And of course, this will make the world a better place. Yes, before I let you go, remember we have the bar book. Remember we started by saying we make the law plain, simple, and entertaining. So this is the entertaining part. What is your Latin maxim for this week?
The Latin maxim that fits into what we're saying remains ubi jus, ubi remedium.
Okay, meaning?
The operative word is shall. It is a right given to this worker that you must negotiate with them. Failure to negotiate with them gives them a right which they can ventilate in law courts.
Okay, remember workers have their rights, and I'll stick with force majeure. You can't hide under force majeure to say you would not do the right thing. Force majeure basically means an act of God or an unforeseen or unstoppable circumstance. Take a look at some more Latin maxims in our bar book segment. You're welcome back. This is still the courthouse, but it's also time for us to go. This is the much we can take this week. We would like you to send your questions to us. We have lawyers like Don Akaegbu who are ready to provide free legal consultation for you. Send your questions coming, send them coming. And remember, we have a special episode where we'll be treating some of your questions. We would like you to join our conversation by using our hashtag the courthouse, hashtag Lover Plus. And we'd like you to download our app Lover Plus on any of the mobile app stores. Remember to visit our website on www.loverplus.tv. I am Olomu-Agbodo. Don't just get mad, go get a lawyer. Bye for now.